Time now for Night Court. The Supreme Court is being asked to take up the case of whether the city of Boston can deny a volunteer organization the chance to fly the Christian flag on the plaza outside its City Hall. Now, Boston has a long-standing tradition of allowing private groups to hold flag-raising ceremonies there, including groups that have hoisted up Pride and Juneteenth flags. Well, the First Circuit Court of Appeals ruled in January that the city can choose which flags end up going on display and has no obligation to fly the Christian flag. Will the Supreme Court now get involved? Let's bring in our legal eagles to debate. Ethan Bearman, owner and attorney of the Bearman firm, and Roger Gannam, assistant vice president of legal affairs for Liberty Counsel. By the way, that's the group that filed the petition to the Supreme Court on behalf of the group that wants to fly the Christian flag. Welcome to both of you, gentlemen.
Thanks for having me,
Shannon.
All right, we're going to start with Exhibit A. This is from Liberty Counsel's petition to the Supreme Court. It says approved flag raisings have included ethnic and other cultural celebrations and the celebration of certain causes such as gay pride. It goes on to say the Turkish flag, which the city has approved at least 13 times, depicts the star and crescent of the Islamic Ottoman Empire. So, Ethan, why shouldn't all flags be allowed to fly?
Well, as the First Circuit ruled, the flags that are referenced there are not primarily religious flags. That's a secondary feature. Those are flags of sovereign nations that are not religious by nature. They happen to have religious elements. Whereas a Christian flag that's proposed by the plaintiffs and appellants in this case, that is a primarily and almost exclusively religious flag that doesn't meet the test. I mean, and more specifically, the First Circuit really drilled into the Summum Walker three-factor test and just pretty bluntly ripped it apart. And I think that's the challenge: is does the Supreme Court want to reanalyze the facts that the lower courts were applying?
Well, and let me read a little bit from the First Circuit Court of Appeals. This is Exhibit B, and Roger, this goes to you. You all are the ones who are fighting to get this case to the Supreme Court. The First Circuit Court, though, in ruling against this group, said because the city engages in government speech when it raises a third-party flag on the third flagpole at City Hall, that speech is not circumscribed by the free speech clause. The city is therefore entitled to select the views that it wants to express. Roger.
Well, the First Circuit definitely got this wrong. First of all, the city of Boston has designated its flagpoles a public forum, and that means that we have free speech rights. The city can designate any of its property to be a public forum, and then the city went as far as to invite all of the diverse communities of Boston to apply to raise their flags there. And over 12 years and 284 flags, the city said yes. The city never said no until my client, Camp Constitution, asked to raise the Christian flag. And the city official who said no didn't care what was on the flag. In fact, he testified under oath that the only reason he denied it was because it was called a Christian flag. If my client had simply called it the Camp Constitution flag, he said he would have approved it. So clearly, the city of Boston is not being consistent is the best thing I can say about it. But more than that, the idea that this is somehow Boston speaking when it invites all of these outside groups to raise their flags and says yes to all of them until our client applies. This isn't the city speaking. This is a public forum for the speech of all these various organizations. And Boston was quite happy to host all of these organizations until our client applied. That's unconstitutional discrimination against the Christian viewpoint of our client.
And that gets to this Exhibit C, which is a Boston Globe opinion piece that somebody wrote. Said City Hall's third flagpole has traditionally been open to all flags, and the city never took a position on any message those flags conveyed. Can it really claim now that all the groups it said yes to over the years were actually engaging in speech sponsored and approved by the government, and only the Christian flag is beyond the pale? Ethan, to you, and then I want to give Roger a final quick comment as well.
Yeah, I mean, really briefly on that, again, none of them were religious groups. And interestingly enough, and I think that this is actually quite relevant, amicus briefs were filed by the Anti-Defamation League and a Sikh group on the side of the city of Boston. So religious groups are against what the plaintiffs are arguing here.
Roger, your best argument to the justices to take this case up.
No one believes that the city of Boston endorses the policies of the country of Turkey, of China, of Cuba, and yet it gladly flew all of those flags. The idea that somehow the city is endorsing the message of these flags by literally opening it up to everyone and saying yes to everyone, it doesn't make any sense. Clearly, this was a case where the city didn't want to let the Christian group raise its flag. Ironically, Camp Constitution and the city known as the Cradle of Liberty can't raise its flag because they talk about civics from a Christian viewpoint. We think this is a case that the Supreme Court should take, and we're hopeful that it will and reverse the First Circuit.
Well, we will track it and let our viewers know. Ethan and Roger, thank you both for making your arguments with us tonight.
Thank you for having me.
Thanks, Shannon.